Good afternoon, everybody. Happy Tuesday. I'm gonna wait till some people join. So before I get started, I want to ask a question. What do you guys do in the music industry currently, or what are you interested in? I would love to know your answers. So please drop your answers in the chat so I can see what you do or what you're interested in learning today. We see songwriter, artist, management, screenplays, making videos, a producer, tour management. Okay. Music for a film, entertainment attorney. Oh, look at all the attorneys on here. I love to see it. Oh, we don't want you to do everything yourself. Let the lawyers do the lawyering and the artists do the artist. So you're gonna learn today. I'm gonna give you some tips today about the music industry. I love it. So I'm gonna start. Let me start the presentation. Okay, so I'll give you an introduction. My name is Shakima Mendez. I'm an attorney. Today, I will be hosting your webinar today. Thank you for Yellowbrick for the opportunity for me to be your host today. Today, I'll be giving you legal tips about copywriting, intellectual property, and contracts, and how to navigate the music industry. I am an attorney, but this is not any legal advice that I'm giving you. I'm solely just giving you gems, very valuable tips for you to navigate the music industry, because the music industry is a business. So firstly, I'll start off with, what is a copyright? A copyright is a tangible copy of your works. So what this means is that any record that you record, that is your copyright. Any lyrics that you write down, I don't care if it's on a napkin, notebook, on Word, in your email, that is your copyright, and you're automatically protected. So you have exclusive rights as the owner, which means that you can exclude anybody and everybody from using your work without your permission. I provided a link to the copyright title that this is specific to. So once you write down your lyrics, or once you record a song, or once you produce a beat, that is your copyright. You are protected. So what is copyrightable? Not everything is copyrightable. One, it must be original, meaning you didn't copy from anybody else. And secondly, it must be of a creative work, which means that it's not too general, it's not too common in the commonplace. For example, you're not going to copyright commonly known facts, which will be the sky is blue or the sun is yellow. You're not going to copyright that. That's not anything that is copyrightable. So next, we're going to talk about the rights that you have. We're going to talk about the rights that you have in the US. So it's very simple. You don't have to go to the copyright office for your work to be protected. As soon as you write it down, as soon as you produce a beat, and as soon as you record a song, that's your copyright, you are protected. I just want to keep on repeating myself because I want to be very clear on that front. So in the US, you have the exclusive rights to reproduce, distribute, perform, display the work publicly, and make derivative works. If anyone uses your work without your permission, this is a violation, which is called an infringement or copyright infringement, and which I will talk about later down in the line. That's the juicy stuff. So where's your copyright protected? It's protected worldwide. You don't have to file in each country. Can you register your copyright? Absolutely. You can visit the US Copyright Office. Will you retain rights without registering? at the Copyright Office? Absolutely. How long are you protected? So since you're the copyright owner, you're protected for 90 years or your lifetime plus 70 years. That's a long time. Your copyright might outlive you. Is your copyright protected outside of the US? Yes, it is. And what happens once the copyright expires? It becomes public domain and everyone can use it freely. And if you have any questions, please drop them in the chat. I will look at your questions. Hopefully I'll be able to answer your questions, but please just fire away in the chat with your questions. I will answer them. Kristen will send a replay, and this webinar will be available, a copy of all of these valuable tips. So as soon as you create your work, you are protected, meaning you don't need to use the copyright symbol, but you can if you want to, just to put people on notice that this is your work, this is your copyright. After March 1st, 1989, any works that was created after that date, it wasn't necessary for you to have the copyright symbol. It wasn't necessary for you to put all rights reserved. It was okay. So now you are protected. You adding the copyright symbol or all rights reserved does not give it any more validity of your copyright protection. You are protected once you record a song, once you write your lyrics, and once you produce a beat. So you can, if it makes you feel comfortable, if it makes you sleep better at night, to put all rights reserved or the copyright symbol, by all means, please do it. But it's not necessary for you to be protected, for your work to be protected, for your music, for your beat. So next, we're going to talk about the usage of the copyright symbol. You can use the symbol. I've kind of already talked about it. You can use the symbol if you want to. It's not required anymore. It's optional. It's optional. It does not give you any more protected rights. So go ahead, put your artist name, your company name, put a C next to it, put all rights reserved. It honestly, it doesn't matter. You're protected as soon as you create a tangible copy of your work and it's yours and it's creative. So I'm going to provide you examples on how to identify your work. You can put the copyright symbol, the year, your name, copyright, period, the year, your name, or copyright, the year, your name, and all rights reserved. This will be good to put, but it's not necessary, as it will put people on notice so they can have notice that this is your work. It belongs to you. Nobody else, it belongs to you. So in the event that they do copy your work, you can be like, hey, I have the copyright symbol, I have all rights reserved, this work is mine. Okay, so let's see. How many copyrights to a song? So there are copyrights to a song. There's actually two. You have the composition, which is the lyrics and the melody, and you also have the sound recording, which is whatever is playing on the speakers, with whatever we actually hear. So the composition copyright, that belongs to the songwriter, and the sound recording copyright, that belongs to the person or the group who records the song. So if you didn't know, today you know there are two copyrights to a song. Here is just a little chart that I pulled up on the internet just to show you kind of like a pathway. Bob Dylan song, this is the song. It created two copyrights, which is the sound recording that I spoke about and the composition. The sound recording is the lyrics and the composition is the melody and the lyrics, and the sound recording is what you actually hear. Once you have those two copyrights, it breaks down into rights, which is the synchronization rights, which is used in licensed film and TV. Then you have reproduction rights when it's sold or streamed. And then you have performance rights, which is played in public. With the composition, you have synchronization rights, again, when it's played in a film, and mechanical rights when it's sold or streamed, or performance rights when it's played on the radio. So now you know that you are protected whether you register your work with the Copyright Office or whether you use the copyright symbol or the all rights reserved. You are protected, it's your work, it's your copyright. So next, we're going to talk about the exceptions to your exclusive rights. As you see in the chart, you do have exclusive rights. You can exclude anybody and anyone from using your work without your permission. Anyone. And this starts to create a monopoly. So there are some situations and limitations on your exclusive rights, which means that people can use your work without your permission. Firstly, I'm going to talk about fair use. With the fair use, according to the copyright law, anyone can use your unlicensed copyrighted work without your permission. All they have to do is pay a fee, pay a statutory rate that is licensed by the Copyright Office. Types of uses of fair use is criticism, comment, news reporting, teaching, scholarship, and research. With the court, they consider 4 factors when determining fair use. Firstly, the purpose and character of the use, including whether the use is of a commercial nature or is for nonprofit educational purposes. So here with this factor, the court will usually permit any fair use of your unlicensed copyrighted work that is non-commercial nature and is for a nonprofit educational purpose. Now with the court, it's a case-by-case basis. So this doesn't give a guarantee just because it is for a non-commercial or nonprofit educational purpose that this is gonna be considered fair use. So it's a case-by-case basis. Secondly, the court will look at the nature of the copyrighted work. So the court will look at the use of the work to determine if it equates to the purpose of the copyright owner. So the unlicensed use of the copyright protected work must match with the purpose of the original copyright owner. Thirdly, the court will look at the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So here the court will look at the quality and quantity of the unlicensed use of the copyrighted protected work by that individual. Lastly, the court will look at the effect of the use upon the potential market for or value of the copyrighted work. So here the court will ask the question on whether the unlicensed use of the copyrighted work by this individual will negatively affect the current or the future market of the original copyright owner. So with fair use, people can use your work without your permission under certain circumstances without your permission. So now we have a compulsory license. This is where the individual can pay a fee, statutory rate for using your work without your permission. Once you record that song and it's released and it's played in the public, you must issue a license. There's no running around this. Once you record your work, once you publish it to the public, someone can pay a rate, pay a fee in order to use your work without your permission. Now, this is only applicable to non-dramatic music compositions and streaming, digital downloads, and sound recording. So it wouldn't be applicable to drama musical compositions like opera. So sorry opera folks. So how compulsory license work? First, the copyright owner must license the song to anyone who wants to use it for audio use only. Secondly, the license can only charge a specific payment established by law. So if I want to use your music or I want to use your beat without your permission, all I have to do is file a notice of intention to you, pay a fee by the Copyright Office. They set a fee, a statutory fee or statutory rate, and that's really basically it. I can get royalties off of your compulsory license, easy. So in 2019, 9.1 cents per song and 1.7 cents per minute is what the US Copyright Office will charge. So I put a link here for the US Copyright Office for the current rate. You can check it. I checked it for you. 2019, the rate is still fine. If you want a more in-depth guide on compulsory license, I also provided a hyperlink for you. So you're not entering the music industry if you don't want to get paid. So you're not releasing music, or you're not producing beats just for your own self. You're producing it because you want your work out there, you want to be heard, you want to go into the music business, and you want to get paid. So I'm going to show you ways on how you're going to get paid. First, you have to register your music with a site. So this is for any independent artists that's out there that's starting off and don't want to really jump the gun and go into a record label contract. Try to use these 3 sources that I provided for you to see how your music does, what your fan base is, how much money you're making as far as royalties. So we have CD Baby. You have CD Baby. This is for songwriters, music distribution, for selling music. It assists with placing music on Apple Music, other DSPs as far as YouTube and Spotify. Then you have TuneCore. This helps. It's similar to CD Baby. It sells music online, music distribution, and you collect royalties. And then you have the orchard.com. So these three sites, make sure you read the terms and conditions. You don't know what their commission is. What are they taking off of your plate as far as revenue? So when you're signing up for these sites and registering your music, please read the terms and conditions. If you need help with reading the terms and conditions, then I can help you. But these are 3 great resources that you should use to register your music to receive some money. So next, we're going to talk about all the DSPs out there and royalties. So digital service providers really changed the game for the music industry, really changed the game for royalties. I can go into royalties so much in depth, but there's just not enough time on this webinar. So DSPs like Apple Music, Spotify, and Tidal does not calculate the royalties by a fixed pay per stream. So what they would do is they would look at factors. They will look at the listener's country and location, whether the listener has a paid subscription or free account, the specific artist royalty rate, and the relative pricing and currency in different regions. So if your music is doing well on, let's say, YouTube, and you get 1 million streams, we know you're not making that much money. Like 1 million streams does not equate to $1 million. So just be very cognizant of these terms and conditions of all these DSPs and how they calculate their royalties. I'm going to show you the next slide of the different types of royalties there are. So first, we have the mechanical royalties. This is usually generated through physical or digital reproduction or distribution of copyrighted songs. This applies to CDs, digital downloads, and streaming service. I want you guys to drop in the chat, when's the last time you bought a CD? I haven't bought a CD in I don't know how long, but I want you to drop in the chat, when's the last time you bought a CD? So secondly, we have performance royalties. This is generated through copyrighted songs that are performed, played, recorded, or streamed publicly. And then we have performance royalties. This is divided up into 2 categories of royalties, songwriter and publishing royalties. Royalties is very difficult, very, very difficult. The digital world and streaming really changed the game. So next, I'm going to talk about mechanical royalties. This is for streaming royalties. This is collected by a mechanical licensing agent. So examples of a couple mechanical licensing agents that you can go through is Harry Fox and Song Trust. Again, please read the terms and conditions. You need to know what you're signing up for. You know, I feel like we tend to, you know, when we open up a bank account and it says, please accept all these terms and conditions, or we're signing up for Apple or Netflix and we're just checking the box and, okay, I accept all the terms and conditions. We don't even know what they're asking of us. So with this, when it comes to your money, please read the fine print and please read the terms and conditions. Self-education is a big thing. And if you can't understand the legal jargon, reach out to me. I got you. So next, I'm just going to give you a side-by-side play of the streaming royalties of the music sites that I told you guys to register your music at. So CD Baby charges a percentage of the money from the downloads. They get a little piece of the pie. And then if you are a CD person, you can get your EP, your album, your single. You can make a CD with them. They also do digital distribution. They have a lot of partnerships with DSPs out there. So meaning you can get your music on all platforms. They have 150 DSPs that they can place your music on. So that means a lot of money. But again, you need to know what they're charging per percentage when it comes to their commission and when it comes to your money, because it is your money. TuneCore, TuneCore allows you to keep 100% of the sales revenue from the music you distribute. It's only digital distribution only. So if you're a CD person, sorry, I would go with CD Baby. And also they assist with digitally distributing your music, your single, your album, your EP, whatever it is. They're distributing it all over on the digital web of all Apple, Tidal, Spotify, YouTube Music, Google Play, you name it. So this is kind of just a screenshot that I took off of their website. You pay a $75 setup fee. Your commission, they get a 15% commission, which is not too shabby. And then they have a 20% sync commission. You keep 80% of the revenue. So you keep 85% of the royalties collected, which is, I think that's good, especially starting off. Here goes an example that I also took from a site to show what they charge per stream, and the numbers are tiny. So it's not that much money per stream. I also provided a calculator. So say you're already on the DSPs. There were some artists already on here that joined the webinar today. Here is a calculator that kind of gives you an estimated calculation. I thought this would be nice for me to provide you. So I don't know what your streams look like on any of these sites, but try it out. There's a drop down of every DSP and see how much money you're going to make. So with the music industry, there's a lot of moving parts, okay? So I seen some songwriters on here. So for the songwriters, this slide is for you. I'm going to provide you with 3 different ways that you can get paid as a songwriter. First, you can license your music. You can assign rights to your musical works to publishers. And music publishers, they're good with kind of grabbing wherever your songwriting music is and kind of bundling that up and distributing your royalties. And they collect them. They do all the work for you, so you don't have to do it. These are called pros, and I'll later explain that. So split sheets. If you didn't learn about split sheets before, you're gonna learn about them today. Split sheets are very important. Everyone is creating music everywhere. They create it online. They're creating a studio. Please make sure you have a split sheet. Now, a split sheet says, so say the songwriter wrote 85% of the song. Please have it in writing. The split sheet will have it in writing. You wrote 85% of the song. You have ownership of that percentage of the copyright, and that will give you your percentage of the royalties. Talk about money first. Money is not a taboo. Music is a business. The music industry is a business. Please have the talk up front. Yes, please create your music, be creative, put it out there, but let's get it in writing. I cannot stress enough, please have everything in writing. Email exchange, I can help you with the split sheet. So before you leave that session, have people sign away, put their names and put the percentage, because if this song goes viral, you don't want to be fighting or you don't want to be in court on who owns what. So secondly, like I said, you can affiliate with the pro. This is a performance rights organization. You probably already know them, ASCAP, BMI. So they help both songwriters and publishers license their works. Like I said, they bundle it from everywhere, the radio, TV, streaming service, bars, restaurants, arenas, and they collect all of that and you receive royalties from that. Like I said, the most common are ASCAP, BMI, and SAC is invite only. So maybe just look at ASCAP and BMI going forward. You know, if you're starting out, all of these sites cost money. So you have to really allocate, you're putting the money in and what are you going to get out of it? That's really the goal. But believe in yourself, believe in your work, put the money in, it all going to pay off at the end of the day. Thirdly, you can do a mechanical compulsory license. Here, you can register with the MLC, which I provided the link. Just a hyperlink that you can go and you can read up on the sign up. You can read about the terms and conditions. So with the MLC, you have to make sure that you are identified in their database. You match the songs to recordings being streamed and downloaded. You are either the owner or the co-owner, and then you provide your payment and tax information. So definitely visit the MLC.com for more information, more in depth. But as a songwriter, you can affiliate with the pro to do all the work for you. You definitely sign a split sheet. That's like for free. Make sure you have a split sheet in place. And then thirdly, you can do a mechanical compulsory license. So for all my producers, my mixers and engineers, I'm going to tell you how you are going to get paid. Okay, so with a producer, mixer, or engineer, you can obtain royalties by a sound recording compulsory license. So there is this letter of direction. So basically the letter of direction authorizes an administrator or a music publisher to act on your behalf to collect royalties and to help you with your sound recording compulsory license. So the featured artist directs Sound Exchange. I also provided a link below for you to go to Sound Exchange to learn more about their facts if you're a producer, mixer, or engineer. To pay a portion of their royalties to the producer, mixer, or engineer via a letter of direction. So featured artist does not mean, I'm sorry, but we love you, background singers, drummers, anyone that's kind of helping you, they don't count. They don't get any royalties. 2, for sound recordings fixed before November 1st, 1995, if both the qualified contributor and Sound Exchange attempt to obtain a letter of direction through a formal process and the featured artist does not make an further objection. So please visit the site Sound Exchange for more information. I see all the chats and the questions. I promise I'm going to go through them. And at the end, I definitely will answer your questions. Or you can have a music producer agreement in place. So say you co-produce a song with someone. It's not clear who's entitled to what. Like I said, in this world with TikTok, Instagram, Reels, all social media, it takes one moment for you to to go viral. You do not want to be arguing about money down the line. Please have it in writing. Please have everything in writing when it comes to music and your contribution, because it's definitely going to affect you in the long run when it comes to money, when it comes to copyright, and that is very important. Make sure you take care of business first before you are creating. That is a tip. It's not a legal tip, but it's a tip. So, you know, maybe it's a situation where you think you own the recording, but the music producer considers they should get a share of the masters because they agreed to record your song. A music producer agreement will alleviate all the legal stress that you probably have in your mind right now. So signing the agreement will it will tell you who owns the composition and sound recording copyrights. It also will tell you about how the music producer should be compensated. This is very important. Or you can do a work for hire agreement. So this is a scenario where other musicians, the drummers, the saxophoners, they're playing on your recording. They might think, say this song goes viral or you're getting a lot of money from royalties on this. Maybe they think in their head that they're part of your band, they're part of the song, they're gonna get a share of your copyright. Absolutely not. So having this work for hire agreement will make it very clear to all parties involved that they are just playing the back, okay? They're just helping you create your work. And this work for hire agreement will make it clear that you own 100% of the copyrights related to the sound recording and the underlying composition. So if you didn't learn anything from me, if you're a songwriter, producer, or even an artist, please have everything in writing. Simple, have it in writing. Let's talk legal. This is why I'm here. I'm the lawyer. I'm not the expert, but I promise you, I am putting you in a position better than your favorite artist, okay? There's so many fights right now that's going on. Who owns masters? How can I get out of a bad deal? I'm not getting paid much. Oh, my lawyer this, my lawyer that. You don't have to worry about that. You're probably gonna be far ahead of the game. Either you're a newbie to the music industry, or you're already in the music industry. Like I said, self-education is very important. Now, you should have a lawyer on hand that you can talk to that can help you with all the business aspect and legal aspects of things. I'm not saying have a lawyer on retainer. I'm saying have someone like me. Have someone like me who can sit here and really advocate for you, because it's not fair when it comes to record deal companies and the bargaining power. It's just not fair at all. So I can definitely help you with any agreements or any trademarking, any copyright, anything you need, I got you. So self-educate yourself, have a lawyer readily available to you. Don't turn blind. Don't just have your lawyer do everything. Ask questions. I always ask questions. Please ask questions. If you don't understand something, ask questions. It's your livelihood, it's your money, it's your bank account, it's your work. Don't turn a blind eye. So there are two types of lawyers in the music industry. You have a litigator, which you see go to court with their briefcase, and then you have transactional lawyers, which you'll see with a briefcase, but they'll probably be behind the desk on the phone, handling all facets of the business when it comes to contracts, when it comes to money. So when do you need a lawyer? I'm gonna provide you 7 situations where you need a lawyer. So prior to signing an agreement with a personal manager. So I seen that there was artists on here, and there was artist management, and probably a manager of an artist. So before an artist signs an agreement with the manager, please have an attorney look over that. You know, they're asking for a commission. Managers do a lot, and they're asking for commission. So you don't know what the term of the contract is. You don't know how long you're gonna be locked in. What if you don't like this manager? So before you enter into a contractual obligation with your manager, have an attorney look at it. It can be a one-off. This attorney, like I said, does not have to be on a retainer. It can just be a one-off. They can help you with this contract. If you're looking to go into the recording deal side, Atlantic, please have a lawyer with you. And this is very important. Have a lawyer that will protect your interests, okay? That's very important. There are some lawyers that are working for the label and working for the artist. The artist doesn't know that, you know, there's 2 conflicts of interest there. Who has more money? The record label. So the lawyer is going to be more on the record label side than the artist side. I'm sorry, but that's just very clear cut. They're not going to advocate for you. And then, you know, there's a conflict of interest when it comes to artists and when it comes from the lawyer working with the record company. So usually an artist will clear that conflict of interest, and then, but there is still the conflict of interest. An attorney shouldn't want to be the lawyer for the artist and the label, but I get it. Sometimes it's all about the money. Before you sign a licensing deal, This will be a contract. Make sure you have a lawyer review it. If this is a copy infringement case, I will talk about this later in detail. When you want out a bad deal. Let me tell you something. A lawyer will find a comma, a word, a sentence that will get you out of a bad deal. We're very strict, okay? So if you want to get out of a bad deal, please hire an attorney. When you want to register a trademark, please don't try to do it by yourself. As an artist, stay in your lane, let the lawyer stay in their lane and do the lawyering. You shouldn't even worry about all these legal documents because you're not going to understand the legal jargon. You're not going to understand the clauses that are in these contracts or in the process of trademarks. Sometimes it's back and forth. You're not going to know what class to register your trademark. Let the attorney do it. You're not going to ask me to sing. You're not going to ask me to go into the booth and sing because I can't sing. I'm sorry, but stay in your lane as an artist and let the lawyers stay in their lane and help you out. It doesn't cost that much money. Find an affordable lawyer and you'll be trademarked. It takes time sometimes it's quick, sometimes, but you should be worried about creating more than the legal aspects. Be aware of the legal aspects, but just hire an attorney for that. If it's in a publishing deal, please have an attorney. So anything that requires money, things that you don't understand, don't just sign your life away, especially with a record deal contract. Don't sign your life away. You know, I feel like sometimes people want to run to record deal contracts and just sign it because, you know, the record label said they give you $1 million advance. That's a loan. That's $1 million loan. You got to give that money back. So I would love to talk about record deal record deal contracts. Maybe Yellowbrick will have a record deal contract series. It's a whole webinar within itself, but I'm not going to go too much in details about that. So we're going to talk about copyright infringement. Somebody used your work without your permission. What can you do? I'm going to give you four things that doesn't cost too much money for you to do if there is a copyright infringement. So whether you put the copyright symbol or whether you put the all rights reserved after your name, after your work, you're still protected for 95 years or your lifetime plus 70 years. Let's be very clear. You do not need to register with the Copyright Office. However, if this does happen, copyright infringement, it's very important that you do register your work with the Copyright Office. Now, if you are a beginning songwriter, I wouldn't run to the Copyright Office. I will just wait until somebody bites. Okay, if it's a situation where somebody bites and use your work without your permission and you use these tactics that I'm going to explain in a little bit, and they either were non-responsive or they didn't want to give you your credit. So you can file an authorship for a work dispute claim. So this is a disagreement over the authorship of the musical work. So in order to resolve the dispute, you have to prove that your work is original and you are in fact the original creator, meaning you didn't copy it from anybody else. 2, be sure to have the timestamps of original files to show when the work was first created. Now this gets a little tricky because we live in a digital era, we live in Photoshop, anybody can change the timestamps and things like that. So either print it out, I would say, just to have a copy of your work. So even if somebody alters the timestamps or anything like that, you will be like, here you go. This is a tangible copy for you to see that this was the actual date. And 3, sign a split sheet. Talked about that. Then we're going to talk about your legal recourse when it comes to copyright infringement. So you can sue the individual for copyright infringement. That's going to cost money. It's going to be a lot of time. You know, these cases are dragged out in court. So before you can even sue, you have to make sure that your work is registered with the Copyright Office. So this is where I say it's kind of like, you know, you don't have to copyright it or run to the Copyright Office to be protected. However, if this copyright infringement happens, you like need to run to the copyright office and register your work. As I said previously, file an authorship for a work dispute claim, or we can be cordial and we can contact the innocent infringer and say, hey, this is my work. Can you credit me for this? And if they're evasive, non-responsive, then we can go to number 4 and we can send them a cease and desist letter, okay? And this cease and desist letter will make it very clear. It'll be in writing, like, hey, this is my copyright. I'm the creator. If you do not take this down, then I'm taking you to court. Usually you give them 14 days to respond to your cease and desist letter, and I can help you with that as well. So register your copyright with the Copyright Office. This will be good to copyright infringement cases. This will be good for additional legal protection when it comes to legal disputes. If you register with the Copyright Office, you're able to sue for any copyright infringement that occurred within 3 years before filing the suit. So you can only file the suit for copyright damages within 3 years after infringement occurred. So you can register your copyright as the hyperlink as I provided for you if you want additional protection legally and to solve legal disputes. But you are protected, and I gave you 4 different ways that doesn't cost money that you can reach out to the innocent infringer. You can file a cease and desist. You can do 4 different things before we even get to court, and before you're spending so much money and then you feel like it's not worth it and everything is getting dragged out. So advantages of why you should register with the Copyright Office. So you can collect compulsory license royalties. This is the license that I talked about that discussed that people can pay the U.S. Copyright Office for a fee and file a notice of intention to use your work without your permission. They're receiving royalties. You want to receive royalties too. Failure to register within 5 years after the first publication of work, you lose legal presumption that everything in the registration is valid. So usually the burden will be on the other party, the innocent infringer, to say this is their work. So if you do not file within 5 years, you will have the burden of proof to prove that you actually are the creator, this actually is your work. And that shouldn't be the case. If you don't register with the copyright, you cannot recover attorney fees nor statutory damages. You can file a copyright infringement action to recover damages or to stop someone from using your song until you're registered. With this recent case in 2018, you actually have to have the registration in your hands before you file suit. So this is why these are some advantages that would be down the line if it gets really messy on why you should register with the Copyright Office. Will you win your case? I mean, it really depends. Like I said, the court is on a case-by-case basis, but they do look at certain factors to determine if you will win your case. So they'll look at the strike and similarity. So what this means is, like, there's 2 songs so similar that someone copied your work. Then you have substantial similarity. That's like a lower threshold of strike and similarity. And then you have the infringer had access to your work. So just because you load a song on YouTube or just because you load it on the internet, that's not how the court will assess the access test. So they will do an access test that says, did your song make top 50 on a credible record chart? That's what access is considered to the court. They'll also ask whether your work is protected by copyright, meaning you're the original owner, you didn't copyright from anyone else, you didn't copy from anyone else, and it's of created work. It's not too general, it's not too much in the commonplace. So sharing music. Please share your music. Right? This is why you went into the music business. Share your music. The students that are signed up with the certificate program, share your music. If your professor is asking you to share your music for an assignment, please share it. You're protected. It's a tangible copy. It's your work. You have different legal recourses that you can take if someone is using your work without your permission, okay? So you're not gonna create music just to keep it to yourself, right? So share your music. Don't let that hold you back. You can go viral in a second. You know, you can get a record deal in a second. So don't let that hold you back from sharing your music. You're copyrighted, protected. Don't worry about it. Do your thing and share your music with the world. So how to protect a song or beat? I mean, you can file with the Copyright Office, but like I said, once that beat is done and once that song is recorded, you're protected. It's a tangible copy of your work as long as it's your work and as long as it's creative. It's yours, you're protected. So you sign up for SoundCloud, someone using your music, they're not crediting you for your music. What you can do is you can either file your work with the Copyright Office to avoid this, or you can, or if an individual uses your music on SoundCloud without your permission, you can do a Creative Commons license. So a Creative Commons license is a license that provides another individual permission to use the work. So you must be the original copyright owner. I also provided a link for you to learn more about a Creative Commons license. So there's also, if somebody uses your work without permission on SoundCloud, I provided a link with instructions for you to file a claim. So you do have some recourse you can on SoundCloud. So don't be scared to, there's so many artists that have been found on SoundCloud. So don't be scared to share your music on those types of platforms. They have recourse. You just gotta read the terms and conditions, or you have to go to the general facts. And I will also, for SoundCloud, I would need you to read the terms and conditions to make sure, you feel comfortable with sharing your music on that platform. And we have Mixcloud. They also have terms and conditions that you can read in section 10, where it tells you how to file a claim for copyright infringement. I also provided a link down here that you can go to. And if this ever happened to you on Mixcloud and you didn't know where to go, here's the section 10 of the terms of use that you can go to figure out your copyright infringement claim. So we're going to talk about intellectual property. We're getting near to the end of the presentation. I don't know if I flew through this or I mean, this slide was 47, this presentation was 47 slides. So I'm going to talk about intellectual property in general. Okay, so intellectual property is anything that you created, your beat, your music, your brands, your company name, your idea, your invention. That's intellectual property, and make sure that you protect it. We already talked about one category of it, which is copyright. I showed you the ways on what is a copyright and how you protect it. If someone infringes on your copyright, what can you do? So the intellectual property law derives from the US Constitution. And then the main categories of intellectual property is trademarks, which protects brands and the logos used in goods and services. You can register your trademark here. I provided the hyperlink for you. Copyrights, I already discussed it in depth. Patents, this is if you have an invention. You can register your patent right here. A trade secret, make sure it's a secret. Okay, so once you blurt that out to someone, it's no longer a secret. So you have to make sure it says that this is actually a trade secret. You don't communicate with anybody else. Just make sure you take all reasonable steps to make sure that this is a trade secret. So the intellectual property chart. So this is just for your reference. I did this for the copyright. It just tells you all your rights, how long you're protected, your protection as far as trade secret, patent, trademark. So this is just you for your reference to have. And Kristen will share this deck with you after the webinar is over. I'll talk about trademarks a little bit because I've seen some questions about trademark. So in the US, you have the exclusive right to identify source of products. If somebody violates, it's called an infringement. You are protected where used and where you register your trademark. Obviously, registration is available. You do have rights without trademarking and running to get your artist name, your brand trademark. You still have rights. Your protection lasts as long as it's used in commerce, and you are not protected out of the US. You have to file in each country. So this is the last slide. If you need any help, questions, please feel free to DM me at Slay My Contract. You can visit my website if you need help with any contracts that I spoke about today, any trademark and any copyright. I'm your girl, I got you. I will make it a seamless process and I will make it more in layman terms. I'm not a stuffy lawyer. I wanna be very relatable to you, and so you don't have a headache when dealing with legal stuff, because it can be a headache, but I love it. It's a headache to you, but I love it. So I'm gonna end this presentation and I'm gonna answer your questions. Let's see. What are my rates? You can go to slaymycontract.com for my rates. You can go to the trademark site to know the cost specifically. Let's see. Thank you, Jose. Let's look in the Q&A. Do you need to put your first and last name? Will this be for the copyright? Yes. Or your artist name. When is the right time for an artist or independent songwriter to approach an attorney? For contracts, for legal advice. You will want to do it right. You don't want to look at a lawyer as a taboo, you know. I know the lawyer community could be like taboo and stuffy and pricey, but if you're definitely an independent artist, I provided you with a lot of resources today. So as far as making money, but as far as contracts, I can help you with that. Yes, so if you live past 90 years, the copyrighted work, it goes in the public domain. Absolutely. So anyone can use your work without your permission, freely. As a songwriter, what is the right time to approach an entertainment attorney? That's pretty broad, but I would say whatever questions you have for an attorney, I say just go for it. I know most of them are like on retainers, Sade, but you can DM me, you can go on my website, you can email me. I'm really down to answer your questions, because this webinar, what made me want to do this webinar is because you are thinking about protecting yourself. And most of these artists or people in the music industry, that's the last thing on their mind. They just want to sign on the dotted line, make the money, get famous. That's all they care about. So I will definitely help you. Just follow my Instagram handle, Slay My Contract, and I got you. Do you need to copyright your logo and branding, or is that a trademark thing? That's a trademark thing, Courtney. How can artists sue politicians for using their song if they go the appropriate route to use the music through compulsory license? I think for this one, Miko, did you file or send a cease and desist? Or are you, if they use a compulsory license, that means they sent file a notice of intention to you. So did they do that? From your question, I'm thinking no. What is the average cost of the CMO and publishers charging for collecting your royalties? So like I gave you 3 pros, which is BMI, ASCAP. Definitely go on their site, definitely read their terms and conditions to see what they are charging for royalties. Let's see. I'm gonna answer 2 more questions. Thank you, TP. Do labels take a cut of the royalties their artists own? Hello, yes, they do. Okay, they take more than that. They own the masters. They make more money than the artists. Just got to put that out there. What is a reasonable retainer for an entertainment attorney? I don't know. You would just have to search and within your, wherever you live, and compare the prices. You know, when I shop, I go on Amazon, Walmart, and Target. They all sell the same product, and I go with the less one. So that's what you have to do when it comes to finding an entertainment lawyer. Is it only possible to own your own masters if you are independent? No, you just need a shock of a lawyer. You need to be very educated. Like I said, when you're dealing with a record label, the bargaining power is not fair. So there are Nipsey Hussle, he owned his own masters. You know, there's people out there that own their own masters because they had a good lawyer on their side that looked out for their interests. Do I have a book I can purchase? Kiana, should I write a book? Would you purchase my book? Yes, you will. You want me to write a book? Oh, wow. Really? Oh, so maybe I have to look in now and writing a book. Oh, you guys are so sweet. Really? Oh, wow. Is it safe to put your brand up on the web, social media without any trademarking? Yes. As long as you're using it in the commerce place, you can use your brand, put it on social media without any trademarking, but trademark it as soon as possible. As soon as you got the money to do so, trademark it. Oh, you'll definitely read my book. Oh, I think I have to write a book, y'all. What is it? What's a good way to bring up the money talk? I don't care how uncomfortable you are, please bring it up ASAP, okay? That's all I'm gonna say. Don't play with your money. You know, if you're a record deal company, you think they're playing with their money? Absolutely not. So don't play with yourself, know your worth, add tax, okay? Please have that money talk. I don't care if you have to drink 3 bottles of water to ease your pain, to ease your nerves. Talk about the money off the outset. Thank you, Shannon. So any other questions? It's 5 o'clock. I'm running out of time. I'm sorry, guys. Hopefully I can do another webinar to assist you. But like I said, please follow my Instagram at slaymycontract. You can email me, Shakima Mendez at slaymycontract.com, or you can visit my website, www.slaymycontract.com.